Good afternoon, everyone. I'm Kurt Gallagher. I'm Executive Director of HBMA. Thank you for joining us for the second broadcast of HBMA Live. Today, our special guests are Bill Finerfrock and Matt Reiter. They are our Director and Assistant Director of Government Affairs. Bill and Matt have been our long-term partners. They work for Capital Associates, or our outside government relations firm. They have worked with us on a number of issues related to government relations and advocacy over the years. They're going to be here to talk with us about some of the hot topics in government relations in healthcare, whether it's surprise medical billing, telehealth policy, or there's actually new legislation in Congress that they'll talk about that would put restrictions on collections related to medical bills. So with that, I'll turn it over to our host and moderator today, Kunal Jain. Kunal, thank you again for being our partner and agreeing to facilitate these sessions.
Thank you so much, Kurt. Welcome, Bill. Welcome, Matt. It was fantastic introduction. We have been talking for the last 10 minutes about different things, and I'm so curious to learn more about it. And thank you, Kurt. I know you had to go, so if you want to leave, you can drop out anytime. But this is this is my pleasure to introduce Bill and Matt for today's HBMA Live. And in particular, I was very excited because I own a medical billing company in Clearwater area, Tampa, and Florida is half of Medicare state. You know both of them. You know, most of our patients come from Medicare side, and most of the doctors they practice. The 50% of their practice volume is a Medicare practice, but the rest 50% comes either commercial insurances or insurances. A lot of insurances are out of network, and out of network patients are normally the victim of surprise billing. Mm-hmm. And we get a lot of calls, we get a lot of bills, a lot of statements, a lot of aggressive patients and unhappy patients talking about those surprise bills when they look at it. And all the time they are like, oh my God, why did I receive this bill from the doctor I never saw in the hospital? Well, right. You were in the unconscious state and you probably have not seen the doctor. Right. The doctor did come and he did prescribe some of the things. Anesthesiologist, radiologist, you know, those are the things which happens at the bedside when the patient is admitted in the hospital. Right. And we want to know all these stories, Bill. We want to know, give us a little bit background about yourself. Sure. I know you are doing a lot of work for the government, both sides, for organizations as well as with the government.
Yeah, thank you, and thanks for the opportunity to be on HBMA Live. It's quite exciting, and congratulations on this latest offering to the HBMA membership.
Absolutely.
Yeah, as was mentioned, I've been involved, Capital Associates, me personally, and then Matt for the last about 7 years, have been engaged with HBMA to provide government relations, health policy, advocacy, kind of, you know, where are things going for more than 20 years at this point. So, you know, we have seen the organization grow and evolve and change, and it's been exciting to see all the new forms of education that are being offered, and this is just the latest example. You know, surprise billing is an interesting issue, and as you've alluded to, there was legislation that was passed by the Congress, signed by the president late last year, that would really place a lot of restrictions on the ability for insurers or for the providers to charge patients for amounts not covered by their insurance policy when the individual is out of network, but in particular types of out of network situations. And it's these what are referred to, and as you mentioned, surprise bills. So one example is what you alluded to, is the patient goes into the hospital, they're going to have surgery, for example, and they were diligent about identifying that their surgeon was in network. They were diligent about making sure that the hospital where the surgery is going to be performed is in network. They go there, they admitted, and they have the surgery. A couple of weeks later, they get a bill for individuals that they didn't see or don't recall seeing, and it's they were out of network. And it typically would be an anesthesiologist, for example. It could be a pathologist who got a sample that had to be analyzed. It could have been a radiologist that was looking at an image. These are specialties that are typically physicians who are not employed by the hospital, but who cover services in the hospital under a contractual basis. And so because they're contracted, they may not be in network with the same plans that the hospital and the surgeon were in network. They're completely independent. And so there were a lot of stories about patients being hit with very substantial bills for what were these out-of-network costs. The other example that tends to occur for the surprise billing are two. One is a patient's been in an accident, for example, and needs to be transported to the nearest hospital, to the emergency room. And so they transport, and well, that hospital isn't in network. The emergency room isn't in network. And so the patient's being hit with an out-of-network bill, but yet they had no ability to choose. So again, it's a surprise situation. But also in the ER environment, we have surprise billing that occurs where a patient, again, similar to the previous example, has chosen to go to the hospital that is in network, shows up at the emergency room, only to find out that the ER physician group that is covering the ER for that hospital is contracted and isn't in network. And so the patient suddenly is being hit with an out-of-network charge, even though the patient went to an in-network hospital. And so this created a lot of consternation, anger, and patients complaining. And first they went to the states, and so a number of states began enacting what is referred to as surprise billing, and eventually it showed up on the doorstep of the federal government and resulted in the enactment of legislation in December called the No Surprises Act. And essentially the No Surprises Act prohibits patients from being charged for these out-of-network fees when they are in the situations that I've described. They go to an in-network hospital, but get care from an out-of-network provider that they had no choice in. It's an emergency situation where they weren't able to choose. The patient is completely protected. So the doctor, the physician group, the hospital cannot charge that individual under those circumstances for out-of-network. They can charge them what would be the normal out-of-network, but anything beyond what the health plan covers and the patient's responsibility under their health plan, they cannot be charged for. And so
who will determine here is a question, I'm sorry, but
no, that's fine.
So that's the beauty of a live, the question comes to your mind and you ask.
Sure.
So who determines the cost of care at that moment? Because they are not in network,
right?
There's no fee schedule,
right?
And they are not bound by any in-network fee schedule policies,
right?
So let's say, just assume this No Surprise Act comes. What would be the fee schedule for out-of-network from Medicare government?
So, well, for Medicare, there is no such thing as a surprise bill, right? This is only in the commercial because you're either it's only with regard to commercial insurers.
Right, commercial insurance. What policy would they follow?
Okay, so this is a good time, I think, to bring in my colleague, Matt Reiter.
Yeah.
Matt works with me at Capital Associates, and he was very involved in this issue, engaged on behalf of HBMA. Matt, can you kind of explain how the payments are going to be determined now under this new surprise billing legislation?
Fantastic.
Of course. Yeah, Kunal really hits the nail on the head by bringing up that topic, because there's really two sides to the coin of the surprise billing issue. First is the patient protections, which is easy to get consensus on, especially from policymakers, to protect patients by limiting what they pay to basically their health plans in network cost sharing amount. But then the trickier issue is how to determine how a reimbursement rate when no contractual relationship exists between the patient's health plan and the out-of-network provider. And again, it's important to note that this is for the federal law, the No Surprises Act, and that there are state laws which are often different in some of these key details. And it is, we can get to this later, it is going to be a little difficult to determine always which of the law applies. But for scenarios that are covered by the No Surprises Act, the federal law, basically the provider and the health plan will have an opportunity to negotiate with each other to determine, to agree on a rate. If they're not able to...
Isn't it the case right now? It's the same thing.
Well,
when we send the bill, they send us a request, and then we respond to that request, right? It's
yes,
a longer process.
Right. And there's no real mechanism in place for what happens if you can't reach an agreement. But the No Surprises Act adds a mechanism in the form of an arbitration process. So after the 30 days opportunity, if the two parties can't reach an agreement, or if one of the parties does not like the agreement, because the health plan will have to make a payment after 30 days or for whatever they think is fair. And then either party would have the opportunity to trigger this independent dispute resolution process, which is the name of it in the bill, which is really an arbitration process. They have 4 days to trigger that process. And there's a whole set of requirements that we are waiting to see, or details of how that process is going to look, that will be put forward in regulations, which we expect to be issued in the next month or two. And so that will really provide a lot more answers as to what the process will look like.
It would give like a template for resolving the entire adjudication process within a time frame.
Correct.
That's one big win, right? That's a
correct
big win, right? But what about the fee schedule?
Well, they'll work from whatever so as Matt said, the plan will pay the provider whatever the plan believes to be the appropriate amount.
Appropriate, okay.
At that point, the provider then can choose to then go into this dispute resolution process if they feel like it's inadequate. And presumably they would have, or otherwise they would have come to an agreement. But they will at least get some money and then decide what they want to do. Matt, you want to pick it up?
Yeah, and so the legislation is very specific about things that, or types of rates that the arbiter is either allowed or not allowed to consider. And so, for example, they cannot include, the arbiter is not allowed to look at Medicare or Medicaid, government payer rates for these determinations. Because each side cannot, because each side will essentially submit an offer. And this is what's called baseball style. So the arbiter then selects one of the two offers. There's no opportunity for splitting the difference. It's one or the other. And that's a binding determination. There's no opportunity to appeal. And so, and the idea is that these cases will set a precedent, and that the information will be, all the results of these IDR cases will be disclosed publicly, so that there will be ideally the opportunity for a precedent to be set, and they can negotiate without this process. But again, the arbiter will have things that they can consider, things that they cannot consider. And the legislation is clear about that. So, but there are some other finer details which we're waiting for in those regulations. So, in terms of a specific fee schedule, again, I wouldn't say a fee schedule per se will be created, but precedents will be set, and we'll have some general idea based on both those precedents, but also what the arbiter is allowed to or not allowed to consider to try to guide that.
Because one of the things that I think is going to be instructive here too, and supports kind of the assessment that Matt just made. The losing side to this arbitration process will have to pay for the cost of the arbitration. So if you know that you previously had challenged a fee and the arbiter made the decision and went with whatever, let's say, the plan had said, you're far less likely to challenge down the road unless there is new information, because if you lose again, you have to pay for that. So, similarly on the plan side, if they see that the provider is winning, it's in their long-term best interest to simply say, okay, if this is what the arbiter had previously concluded was inappropriate, we might as well pay it, because they're likely to challenge, we're likely to lose, and we're going to have to pay for it. So you're going to get a de facto fee schedule out of this over time.
Two things
Yeah,
to add to that also real quick. First is after arbitration, proceeding concludes, that party is then prohibited under the bill from bringing that same party to IDR for the same item or service. So we're really waiting on a clear definition of same item or service in these regulations, but there will be what they call this 90-day cooling period. However, the second thing, there's also an opportunity to batch similar claims so that you can essentially settle, a lot of similar types of cases in one case.
Yeah. So this is fantastic. So do you think the work for a billing company is going to increase?
Well,
no, go ahead, Matt.
I was going to say also it depends on what types of specialties your clients are in, because the federal legislation doesn't apply really to physician office settings. It's really facility settings. So hospitals, ambulatory surgical centers, freestanding emergency departments, critical access hospitals.
So what about the physicians who are doing out-of-network billing?
Well,
like emergency physicians or hospitalists?
Well, it applies to the providers who are in those settings. So if you look at emergency, radiology, anesthesiology, pathology,
right, and they are large
hospitalists,
groups, so they are like large.
So they are covered by the No Surprises Act because they are providing their care within a facility. But a family physician or a general internal medicine in their office, this legislation does not apply in those settings.
Does not work in the office. We all know that. But what about if a doctor who's a primary care doctor, emergency care doctor, whose 90% work is an emergency department? I mean, there are small doctors. There are hospitalists who are independent. They go, they see out-of-network patients.
Yes.
Where would they go?
If it occurs in the hospital or in one of those settings, then the No Surprises Act covers those situations.
So it would be the same out-of-network, basically. The allocation of place of service would be the same, whether it's a nursing home or assisted living facility or anywhere a patient is seen out-of-network, I'm guessing.
If it's in a provider, if it's in one of the covered providers. So I think, by and large, we're looking at hospitals, standalone ERs that are affiliated with a hospital, independent diagnostic, ambulatory surgical facility, those situations. Again, I think the key for everyone to keep in mind is these are situations where the patient either did not know or had no ability to choose from whom they got care.
Correct.
So, if I go to an urgent care center, and I have the ability to know whether or not, when I'm driving to that emergency care center, whether or not it's in network or not. But if I'm in an ambulance and the ambulance takes me to the ER, I had no ability. So that's really where you need to think about it is, did the patient have an opportunity to choose where they got the care? Did they have the opportunity to choose from whom they got the care? And if they didn't have the ability to choose from whom, or didn't have the ability to choose from where, then there's a good chance the surprise billing legislation is going to cover those situations. But if the patient had the ability to choose where or from whom, chances are it's not going to be covered under the No Surprises Act.
And chances are that it's going to increase a lot of documentation.
I think in the near term, that's probably true. And record keeping, if you think you're going to want to challenge. But again, over time, you're going to have precedents, and it's not going to be case law, but situations where we've already resolved that. Do we need to revisit that?
They might tweak. I think my guess is they might tweak their CMS 1500 form. What do you think? In order to incorporate some of more details, whether it falls under Surprise Act or No Surprise Act.
No, I don't envision that. I'm not sure what you might have in mind, but
because last time, you remember, there was for hospital, they started for auto accident claims. I think they started a accident date has to be mandatory to be mentioned in CMS 1500 forms. So similar type of situation. I'm not sure. I'm just guessing. Like if There has to be a track, because what you said, how would they track the intention of a person, whether he deliberately pick an urgent care center
Right.
who is out of network, or
Right.
he was taken by
Well,
some outside person or an emergency van or anybody.
Right.
the bill does kind of address that, where basically they define, if the patient basically can provide informed written consent at least 72 hours in advance,
Mm-hmm.
and that consent has to basically show that they agreed out of network care. Here's an estimate of the out of network cost. Here's, basically here are also the in-network providers that you can choose from. And if the patient is able to receive that and sign it, then it won't be an issue. But there are according to the bill, they can be billed out of network and balance billed. But the bill, so the legislation is very specific that certain types of specialties, basically the frequent flyers, if you will, for that have to bill patients in these scenarios, would be precluded from offering that advanced notification and being allowed to bill
To
the
be
patients.
seen or to be handled
So
their care.
they really have no ability, if you're one of those specialties, anesthesiology, radiology, that there's really no way to get out of the No Surprises Act protections.
Well, I'm sure it's going to be fun to see how it unfolds in next few months. And you are pretty positive it's going to come. It's coming.
Well, the law says that it is effective as of January 1 of 2022. So, as of January 1, 2022, so what is that, 6 months from now or so, the law takes effect. In the time period between now and then, they'll have to write some regulations to elaborate on some of these issues Matt had referenced. But yes, there's no reason to think that it won't take effect on January 1.
And I think the one last question I have in my mind, how are they going to sell through state versus federal laws? Because some of the states already has it. Like in Florida state, we already have a Surprise Act billing. What do you think about?
Well, this is going to be one of the areas where it's going to be interesting to see what law applies. It's going to be situational. So, this is where it's really going to be a challenge for the billing companies and the providers, because depending upon the type of insurance policy the patient has. So let's say I have Care First, one of the Blue Cross Blue Shield products. Do I have a Care First product that I purchased through the exchange through the Affordable Care Act? Do I have a Care First product I purchased or I'm getting through my employer? Because what law applies will be determinative. But you as a provider, you as a billing company, when the patient presents their insurance card that says Care First, it doesn't say Care First through this. It doesn't say Care First through that. Well, if it's through your employer, there's a good chance it's an ERISA plan, which means the federal law would apply. If it's a Care First policy through a small employer that's covered by state insurance, it would be state law would be applied. If it's a plan that's through the Affordable Care Act, then it's not clear. So one of the things that HBMA was advocating for was that on the cards, we need to put information, or the government should require that there be information on what type of plan this is. Is it an ERISA plan? Is it an ACA plan? Is it a traditional commercial insurance plan purchased under state insurance law, so that you know what law applies when it comes to billing?
That's true. So, this whole authorization process still, it's a havoc for especially small practices. People are just, they're not sure what they're doing. And then the whole training process is so complex these days, and it's becoming more and more complex. So I hope we will have more sessions like this. We are 25 minutes. We are almost 20. We have another 5 minutes. I wanted to talk about a little bit more, but I think we have to cover two more issues. One is there's another very interesting legislation on the cards about virtual visits. People started liking it.
Yes.
I have a next appointment at 1:20 with my primary care. I can go visit her in her office, but she wanted a virtual visit.
Yeah.
So I don't know. It would be they are seeing more patients, or patients are more comfortable to be seen in a virtual visit setting. But it's fun, and I guess like it's going to be permanent, or there are some of the stuff which they are going to keep it permanent.
Well, from a Medicare perspective, it's going to require some changes in the Medicare law. Right now, the telehealth, or as you describe it, a virtual visit, really has a very limited applicability under the law. Under the public health emergency, a lot of the policies that have guided telehealth or virtual visits have been waived. And so the HIPAA requirements in terms of privacy and security, allowing you to use newer technologies, the location requirements, the new patient limitations, et cetera, have all been waived. Once the public health emergency, however, goes away, those waivers go away, and we resort back to the policies that applied. So there's a lot of interest in expanding telehealth policy, changing those laws, because to your point, a lot of patients are now discovering, and providers, that, hey, I like this. This is great. I can do the visit from my home. I don't have to travel. A lot of rural patients who have to travel long distances are finding that they like it. Specialists are gaining access to patient populations that they wouldn't have necessarily had access to. So there's a lot of consumer and provider demand to make some changes, but those are going to require some changes in the law, which we're hoping will occur in the next 6 months or so.
Okay, so then this is not passed yet. It's in the pipeline.
It's in the pipeline.
And it's until then, the emergency, whatever
everything's covered under the public health emergency.
Yeah.
At least through the end of 2021, all those policies will remain in effect.
Right.
What we don't know is what's going to happen in 2022.
Perfect. Well, Matt, this is fantastic. I think there was another legislation which you're saying that Medicare patients age from 65 to 60. Are they?
Well, there's some proposals to lower the Medicare age from 65 to 60. The president referenced it in his budget. Some legislation has been introduced. That's a little speculative at this point. There is an issue, if we could real quickly, though, a different issue I'd like to just make folks aware of, and that has to do with medical debt and debt collection or claim bill collection. Matt, do you want to talk real quickly about this legislation and give folks a heads up about it?
Yeah.
Sure. Yeah. Recognizing that we have only a few minutes left, I'll try to be as brief as possible and just direct people to the monthly Washington reports that come out where this issue will be explained in more detail. But yeah, there was legislation introduced in the House, and it was passed by the House only a few weeks later, that was a large package of debt protection policies for people and families. And one section of that had to do with debt collection practices for medical debt. And it really did three things. First, it would prohibit, and again, it hasn't passed the Senate yet, so it would prohibit debt collectors, so not billing companies, but debt collectors under the Federal Fair Debt Collections Practices Act, from trying to collect a medical debt for 2 years after the first due date of that bill. Second, it would...
So 2 years, he cannot...
Yeah, can't turn it over to collection.
Have to wait 2 years. Yep.
Okay.
That's the first thing. The second thing is it prohibits anyone from reporting medical debt to a credit reporting agency for 1 year. And then third...
2 years.
No, it would be concurrent. So you cannot report it for 1 year. You cannot turn it over to debt collection for 2 years, but those would run recurrent, not sequential.
Correct. And then finally, there's some requirements about if you are going to report patient debt, that the patient has to be notified with some basic information about their rights or opportunities to resolve that debt. So again, it's now in the Senate. It's I guess waiting further action by the Senate Banking Committee. We don't expect this to be a high priority for the committee or for the Senate, but it's definitely something we're keeping an eye on and trying to advocate against having this become law.
Well, this is fantastic, guys. I think we're almost 30 minutes down the line, but before we leave, I wanted to give the name of this interesting book written by, this book is called America's Bitter Pill: Money, Politics, Backroom Deals, and the Fight to Fix Our Broken Health System by Stephen Brills. I know you guys have read it. I have read it. But anybody who is interested and who owns a healthcare company, billing company, MSO that you are hearing to us, try to read this book. I think this describes some of the backroom stories about the architects of Obamacare law. Some good, some bad, some evil, all kind of stories. It's our perspective to look at it. With that, we will end this HBMA live session. Thank you, Matt. Thank you, Bill.
Thank
I'll
you.
see more next Thursday.
And look forward to seeing everybody at the conference in person in the fall.
Here you go, September. Thank
Yep.
you, everyone.
All right. Be well.
Bye.
Thank you.
Thank you, everyone.